Here's what I want you to do. Go through here. Take that list over there. Start at number 1. Right.
The court is going to call 2019 CR 6484 State of Texas versus Kevin Devnav. I have parties announced for the record for the state,
Marcus Sanders.
for the defense.
John Young,
All right, Mr. Young, you stated there was something you wish to put on the record.
court has indicated that you do not require the jurors to unmask. I object to that. It makes it much more difficult to determine what is going on behind their eyes. All I can see is their eyes, and I would object to doing it without requiring them to unmask.
State.
Judge, it's whatever you decide.
Okay, all right. We're going to proceed. Jurors will be allowed to wear a mask if they wish to wear a mask. My understanding from previous jury selections that were done with other judges, the jurors usually do not wear their mask because we have them socially distanced.
And I would also ask that the jurors, whenever they're going to speak, move to one of the microphones that are staged around the room. It's really quite distant. I know the court is aware that I wear hearing aids. It's going to be very difficult for me to hear them. And boy, every time somebody's not in the front row speaks, and I have to ask them to move to a microphone.
All right, we'll make sure that happens, Mr. Young.
Thank you, Your Honor.
All right, other than that, are both parties ready to proceed?
State's ready, Judge.
Bench is ready, Your Honor.
All right, could we bring in the panel, please? And could everyone please rise for the panel?
You're number 43 and you're number 61.
All right, thank you.
Are missing?
Yes.
All right, for the jurors.
I'm sorry, sir, what's your juror number?
It's just one. Yeah,
One,
that's one.
that's one.
Okay, thank you.
Sorry, they changed it on me.
Oh, no, every jurors, please have a seat.
Sure. Go ahead.
Oh, no.
No, the jurors.
No, you're gonna need that.
Oh, I think so. Gotta sit in your number. Yeah, sit for your number.
All right, everyone, please be seated. Good morning, everyone. Okay, that is like extremely weak. We should be like really excited to be here. We're meeting new people. We're seeing new people. So good morning, everyone. So as you can see that we are not in the 187 District Court. We're in the Central Jury Room. My name is Stephanie Boyd. I'm judge of the 187 District Court. I want to make sure that everyone is able to hear me and everyone is able to hear the attorneys. So the person who is, the people who are on the back row, are you able to hear me? Awesome. So first things first, you're here for jury selection, and we appreciate each one of you for coming down. I'm going to allow the attorneys to introduce themselves. For the state, if you could introduce yourself, please.
Good morning. My name is Marcus Sanders.
And I'm Tom Nisbet.
And for the defense, we have.
My name is John Young. I represent Mr. Debman.
All right. So first off, these are certain rules that I'm going to need everyone. When you are speaking, I'm going to ask that you please stand because it's easier for everyone to hear you. I'm going to ask that if you're not on these first two rows, if you will speak at the microphone. I know people hate public speaking. People have a fear of public speaking. But the good thing about your position today is every answer that you give today will be the correct answer. So if there's an exam today, you're going to make an A+ on it. So you can go home and tell everyone, I made an A on my exam today. The only thing that's required is that you be truthful with your answers. If you look around, you will see microphones positioned. Please, there is a mark on the floor where you stand to speak. Don't worry about the height of the microphone. Don't adjust the microphone. Please don't touch the microphone. Just speak clearly into the microphone so that everyone can hear you. So, why are we here today? We're here because this is the United States of America, and when anyone's charged with an offense, they are allowed to have a jury trial. Now, Just because someone's charged with an offense, that does not mean they are guilty of an offense. Just because Mr. Debnap is sitting here does not mean he is guilty of anything. How many people here have had a traffic ticket before? See, this is what I want you guys to do. When I ask a question, raise your numbers. So we're gonna do exercises, okay? So how many people here have had a traffic ticket before? Oh my gosh, we have some horrible drivers in here. I've had a traffic ticket before too, so that's okay. So when an officer pulls you over and they give you a traffic ticket, I've only had one traffic ticket. Yay. But when they pulled me over, because this has been years ago, what they did was they gave me a piece of paper saying, okay, you were speeding. It was a speed trap, but they were saying, okay, you were speeding. So they give me this piece of paper. Now, on that piece of paper, it tells me what I'm accused of, and it tells me where I need to appear to answer for that, right? So when I get that ticket, it's not me saying, oh, thanks for the ticket, I'm guilty of it, right? It's just for them to give me notice. So Mr. Debnap is here today because he's been given a notice. This is what you're charged with. This is where you need to appear. It does not mean that he is guilty of anything. Does everybody understand? So when you get a traffic ticket, if you want to go to traffic court and go to jury trial on that, that ticket is not an evidence of your guilt. It's just a way for you to have information. This is what you're charged with. So Mr. Debnap is here because he's been charged with aggravated assault with a deadly weapon. So he's received an indictment, and in that indictment, it gives him information so he'll know this is what he's coming to court for. This is where he needs to be. Is there anyone here who thinks just because someone has been indicted, that means that they are guilty? Okay. Now, there are certain rights that everyone who's accused of an offense has. First, there's a right to remain silent. How many have heard of that right? The right not to testify. All right, I see a lot of people have watched Mannix, The Practice, Barney B. Jones. Are there any Barney B. Jones people out there in the audience? Thank you, so I don't feel like I'm the only person who's in that age range. So what that means is if you are charged with an offense, you don't have to testify, you don't have to talk to anybody. Those are the rights you have. That doesn't, again, that cannot be used as evidence of guilt. That just means you don't want to say anything. Is there anyone, if Mr. Debnap were to choose not to testify in this case, is there anyone who would hold that against him? The other thing, I mentioned to you that the charge is aggravated assault with a deadly weapon. Sometimes people come to court and they're like, man, I wish I had an insurance case that I was coming down to court for, or I wish that I had a civil case that I was coming for. Well, in the United States, we need jurors when people want jury trials. Is there anyone who feels that because of the nature of this offense, there's absolutely no way I can sit on this case? And before anyone raises their card, when I say, if there's an issue, I mean, will your psyche be so damaged? You're just like, there's no way I'm going to be able to hear the evidence. I don't want to hear the evidence. It's going to do great harm to me. Is there anyone who feels that way just based upon the nature of the charge? Right. Next, the burden of proof. The state has the burden. What that means is they have to prove the elements of the case beyond a reasonable doubt. When I was in law school, we had to memorize the definition of reasonable doubt. I memorized it in my sleep. I knew it forward, backwards, sideways, knew it, could always quote it. Then it was decided that that definition would not be the definition anymore. So there is no longer a definition for proof beyond a reasonable doubt. Now, jury trials in Texas have what's called two phases. The first phase is whether you find somebody guilty or not guilty. The second phase is a punishment phase. Punishment phase, you only get to that phase if you find someone guilty. Does everyone understand? One of the rights that anyone who's accused of an offense has is to decide, do they want a jury panel to decide their punishment if they're found guilty, or if they want a judge to make that call. That call by anyone accused of an offense must be made prior to jury selection. That's the law. Mr. Debnab, in this case, has decided if he were to be found guilty, he would ask that the court decide the punishment. Does everybody understand that the law requires Mr. Debnab and gives him the right to make that choice? Does everyone understand that? Yes. Okay. Is there anyone here who's going to hold it against him that he has decided to come to the court if he were found guilty?
Oh.
Thank you. So this is what I'm going to make sure, and I need to make sure everyone does. Everyone, please remember to keep your voices up. If you're not on the front rows, go to the microphones, speak loudly and clearly. So how many people are going to touch the microphones? No, thank you. People forget that. So don't adjust it. Everyone will be able to hear what you will say. The state is going to get a chance to ask you some questions. Then we're going to take a short break, and then the defense will be allowed to ask you some questions. State, you may proceed.
Thank you, Judge. Can y'all hear me? No. Okay, if I talk louder, can y'all hear me?
Yes.
Sorry, I'm trying not to get too close into your space. My name is Marcus Sanders. Tom Nesbitt, we're the ADAs for the 187th District Court. This part of the trial is called for dire. It's basically our opportunity to talk to you all. We'll ask you some questions. We're not trying to pry into your business. The reason that we're asking the questions is because we need to know if you can be fair and unbiased for this particular case. This is sort of a new experience because we're normally in the courtroom, so this is a big room, so I'll try to keep my voice up. I have a tendency to lower my voice as I'm speaking, so if y'all can't hear me in the back, just let me know. So
Check.
oh, cool. Thanks. Okay, so State of Texas versus Kevin Debnam. Like I said, the question, everything that we're asking, everything that we're doing this morning is to try to find out if you can be fair and unbiased in this particular case. No, it's watching now, so I'll try to read it too. But can anyone give me a reason why someone wouldn't be able to be fair and biased? You start calling on people. No. Yes, ma'am.
They've actually been assaulted with deadly weapons.
All right, excuse me. Everyone, remember, if you're not on the first rows, I'm going to need you to go to microphone so that everyone can hear you.
They might have been assaulted with a deadly weapon.
Thank you. You're number 26.
Yes.
Can anyone think of any other reason why someone can be fair and unbiased? You're number 49.
They may know the person.
They may know the person. And so I guess with that question, does anyone here recognize myself, my partner, Tom, the defense attorney, Mr. John Young, Kevin Debnam, the court, or anyone y'all see in here? You're number 27, yes, sir. You recognize the judge?
I'm sorry, Your Honor, I could not understand what he
Could
said.
you come up, please, sir?
No, I just said I recognize the judge.
Okay, how do you recognize it?
I recognize it from previous experience. I'm trying to remember where I saw it, but I do recognize it.
Well, I guess the fact that you recognize her, do you think that whatever reason you recognize her for, do you think that that would play a part in your ability to serve on this jury?
No.
Would you, I guess, be swayed either one way for the state or defense either way?
No, probably not.
Okay, thank you, sir. Yeah. So the second question question that we're trying to get to is, can you follow the law in this particular case? I know everyone thinks like, yeah, I could follow the law, but I want to give you all an example. When I was a misdemeanor prosecutor, this is a felony court. When I was a misdemeanor, we used to try POM cases before the law changed. So let's say. Can't see that first picture, but that first picture was Cheech and Chong. The second one, Willie Nelson. The third is Snoop Dogg, and the fourth is the guys from Pineapple Express, Seth Rogen and James Franco. Do y'all think that those guys would be able to be fair and impartial in a possession of marijuana case?
No.
Do y'all think that they'd be able to follow the law and find someone guilty in that type of case? So that's why we're here today. That's why I'm going to be asking questions. I just keep that in mind. Lastly, you're going to be asked to take an oath to render a verdict based on the facts and the evidence that's presented. And so, does everyone think that they could do that in an aggravated assault case? Is anyone who doesn't think so? Like the judge said, the case, and I said the case is an aggravated assault case. Who here knows what assault means? You're number 44.
Assault's when somebody causes harm to someone.
When someone causes harm to someone, okay? Anyone else have another?
Physically.
Yeah, I'm sorry, sir, what was that?
Causes harm physically.
Causes physical harm to someone. Anyone else? So what about an aggravated assault? When you hear that word, what do you think? You're number 2.
I think I understand assault to mean that you have received bodily people touched unwantingly, and aggravated means that there's been some sort of damage done.
That's close. That's close. So she said that an assault means you've been touched unwantedly, while aggravated means that there's been some sort of damage. There's actually 2 ways for someone to commit an aggravated assault. The first way is that they commit an assault and they use a deadly weapon, like a gun, a knife, a bat, a sword. And so words that I'm saying today, a lot of the words we use have legal definitions. If you're chosen to be on the jury, the court will give you a jury charge and it'll have a legal definition. I'm gonna have some of them up there, but let me try to break it down and become regular terms. So deadly weapon, a firearm, a handgun, first aid, deadly weapon. There's a second definition that anything in the manner of its use or intended use is capable of causing death or serious bodily injury. Does that make sense to everyone? Yes. So I put this slide here because if there isn't a legal definition, then you're supposed to use whatever the common meaning of the word. And I put this here because it backfired once. I was trying a dating case and the jury charge had the word plea in it. And people were like, well, what does plea mean? What's the legal meaning? So if you're not given a definition in the court's charge at the end of trial, then you use whatever the normal meaning would mean. So back to deadly weapon. Are all of those deadly weapons? The second way that someone commits aggravated assault is by causing serious bodily injury or threatening serious bodily injury. Does that make sense to everyone? And so serious bodily injury has a legal definition. It says bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Juror number 17, can you give me an example of serious bodily injury?
Serious bodily injury could be stabbed to the heart, to the lungs.
Yes, sir, exactly. Anyone else have anything? So a person commits an aggravated assault. This is what I just explained. And a person commits an offense if the person commits assault as defined in section 2201, we'll talk about that later, and the person causes serious bodily injury to another or uses or exhibits a deadly weapon during the commission of the assault. So I want to talk about use or exhibit. When you hear that word, what do you think? Here, number 17.
when they physically brandish a weapon or some other form of attempt for injury?
Yes, sir. That's a good answer. So in this picture, someone's shooting a gun. Would that be using or exhibiting firearm? Let's say that they don't actually hit the person that they're shooting at. Is that still using or exhibiting a deadly weapon? The second one, they're just pointing the gun. They don't actually fire it. Is that using or exhibiting a deadly weapon? Yes. Third one, let's say they don't stab the person, but they run at them with a knife. Is that using or exhibiting a deadly weapon?
Yes.
And then let's say they have a gun and they don't shoot them, but they hit them with it. Is that using or exhibiting a deadly weapon?
Yes.
So what is an assault? We talked about that earlier. There's a legal definition for assault. There's actually 3 ways someone can commit an assault. The first way is intentionally, knowingly, or recklessly causing bodily injury to another person. The second way is intentionally or knowingly threatening another with imminent bodily injury. And then the third way is, we won't really focus on, but it's like an offensive or provocative touching, unwanted touching, which is what juror number 2 explained earlier. So we're going to first focus on the first 2. Knowingly or recklessly causing bodily injury. When you hear the word bodily injury, what do you think? Juror number 9 or 6? 6.
Anytime your body gets hurt,
Right on one shot.
a part of your body.
And she said anytime a part of your body gets hurt. Anyone else, when you hear bodily injury, what do you think? Juror number 77.
I'd say anything that requires medical attention.
Anything that requires medical attention? Anyone else? Juror number 36.
Broken bones, lacerations, any blood showing.
Yes, sir. That's correct. So the stuff that we talked about earlier with serious bodily injury would also be a regular bodily injury. The legal definition of bodily injury is anything that causes physical pain, illness, or any impairment of physical condition. So even if there isn't a bruise, even if there's no blood, if the person feels pain, that's a bodily injury. Does that make sense to everyone? So it doesn't require visible injury. Victims can testify to the pain that they suffered. So my first question, and I'm gonna go around and ask everyone to answer. If there isn't a visible injury from the assault, then criminal charges should not be brought. Does everyone understand what the question is? And so I'm gonna ask if you agree or disagree. And there's different levels. One is you strongly disagree. So again, the question is, if there isn't a visible injury from the assault, then criminal charges should not be brought. 1 is strongly disagree. 2 is slightly disagree. 3 is slightly agree, and 4 is strongly agree. Does that make sense?
Question, please.
Yes. If there isn't a visible injury, so if someone testifies and there isn't an actual injury, do you think that charges should not be brought? Everyone understand it?
You said if there isn't a visible injury the first time, and then you said if there isn't an injury the second.
Sorry, visible injury. So the person testifies that they felt pain, but they don't have any bruises, they don't have any blood. So juror number 1, should charges be brought? Oh, sorry, juror number 5.
So then that would be emotional pain.
No, so remember, you can still feel pain without actually showing injury. Not everyone bruises, correct? Or do you, no, let me know. How do you feel about that?
Okay, all right. I'm just asking the question.
Do you agree with me that not everyone bruises?
Yes.
Do you agree with me that someone could feel pain even if they don't outward, there's no visible
Yes.
signs? Does anyone have an issue, I guess going back to that, with the bodily injury, no visible injury? So I guess, sorry, this question doesn't fit as well in this big room. Y'all have to come to my microphone. So I guess the way that I'll ask it is, does anyone think that criminal charges should not be brought against someone if there's no visible injury? If you could raise your card in the air. Okay, thank you. So the second definition, intentionally or knowingly threaten another with imminent bodily injury. The word that I want to focus on with this one is threaten. A threat can be communicated by words or by acts or by conduct. So let's say that I say I'm going to punch you. Is that an assault? Let's say I run at you and I'm swinging. Is that an assault? Even if I don't hit you. Let's say that I pull out a gun and I point it at you. Is that an assault? And so I gave the pictures up again. The first one, that one actually makes contact, so that's obviously an assault. But under that second definition of threaten bodily injury, is pointing a gun threatening bodily injury? Is running at someone with a knife threatening bodily injury? Is stabbing someone with a knife threatening bodily injury?
Yes.
And is shooting at someone threatening bodily injury? So this question was another one, but I'll just ask. So if the threat, if there's no injury and the threat just consisted of like possible bodily injury, so that let's say you pointed a gun at someone pointed a gun at someone, would anyone have an issue finding someone guilty in that situation? No one? So from time to time, you may hear us talk about elements. This is how everyone's trained in law school. Elements is how we break down each individual law. And it's how what we use to make sure that we prove up everything as a state that we need to. So the elements of an assault, these are the things that we have to prove, that on or about a certain date in Bexar County, Texas, the defendant intentionally, knowingly, or recklessly caused bodily injury to another. And we have to say how they caused it. Does that make sense to everyone? So the elements of an aggravated assault are on or about a certain date in Bexar County, Texas, the defendant commits an assault, which we just talked about, and they either cause serious bodily injury or used or exhibited a deadly weapon during the commission of the assault. Does that make sense to everyone? So that's what we have to prove. Those are the elements that we have to prove to the jury. If you're chosen to be on the jury, beyond a reasonable doubt, and I'll come back to that later. So there were some words in there, intentionally, knowingly, or recklessly. And that's the mental state. And so, does defendant or someone who commits a crime, do they always say what they're going to do before they do it?
No.
So how can you tell what someone's mental state is if they don't actually say it? Juror number 11. Is there any way that you can tell? Can anyone give me juror number 23? You were, I'm sorry. Juror number 15 said actions.
Body language.
23 said body language. Anybody else?
You would have to know their typical behavior.
If you know their typical behavior. All those are good answers. So intentionally, knowingly, or recklessly, they have legal definitions. Just breaking it down, intentionally, it is your objective to engage in the conduct or cause the result. Does that make sense? If someone's intending to do something, they're trying to do that, basically. Knowingly, you are aware of your conduct or understand that the consequences of your actions are likely to cause a result. So going back to intention, let's say Tom's actually my supervisor. And I was like, Tom, I'm sick of you. I'm going to use this opportunity as an example. I'm going to hit you with the box of tissues. And so I swing it at Tom's face. Is that intentional? And how did you know it was intentional? Because I said it and then I did it, right? Now let's say I don't say anything, but I look at Tom, I look at the tissue, and then I throw it at him. Is that intentional? Probably, right? Is it knowingly at least? So the last example, recklessly. It's a conscious disregard of harm that might be caused by your actions. So let's say instead of Tom, I see that y'all are out there. Normally, everyone's a little bit closer together, so it's easier to hit someone. So now if I throw it, I probably may not hit somebody, but let's say y'all were closer and I took this box of tissue and I threw it out there. Is that reckless?
Yeah.
Yeah, because there's a good chance that it could hit someone, and I know that, and I still do it. So back to what I asked earlier, how do we prove mental state? By someone's statements, by their actions, and then just the surrounding circumstances. What we don't have to prove, I talked about the elements. Anything that wasn't one of the elements that was listed, so the honor about a certain day, the defendant committed an assault and threatened bodily injury or used a deadly weapon. Anything other than that, we don't have to prove. A lot of times people ask, why did the person do it? Why did the defendant do it? We don't have to prove that. You may have questions about it, but it's not something that we have to prove because, I mean, a lot of times we don't know why someone did something. So the burden of proof, has anyone heard of that term before? Who here knows what the burden of proof is in a criminal case? Actually, I guess the judge gave the answer, but who here remembers what the burden of proof is in a criminal case? Juror number 62.
That it's the state's job to bring evidence against the defendant?
Yes. So we have the burden of proof in a criminal case, and we have to prove those elements to you. The burden is the level, it's called beyond a reasonable doubt. Has anyone heard that term before? And so there's no legal definition, as the judge said. What we tell the jurors is that you know what beyond a reasonable doubt is. You use your common sense. But I can tell you what it isn't. It's not 100%. It's not removing all doubt. It's not beyond all possible doubt. It's not beyond a shadow of a doubt. It's beyond a reasonable doubt. And so if you're chosen on this jury, that's what you have to remember when you're back there deliberating. This is used in every jurisdiction across the United States by the federal courts and by the state courts down to JP courts. So I would need to be, the question is, who here would need to be convinced beyond all doubt to find someone guilty in a criminal case? Is there anyone? Is everyone okay with holding us to the burden of beyond a reasonable doubt? Anyone not okay with that? So when I talk about some possible defenses, there's no way of knowing exactly what's going to come up in the trial. And I can't get into the facts of the case right now. The voir is just to sort of ask you general questions to get your feelings on things. But we can sort of predict what we think may come up, and so we need to ask questions about it. And so, who here has heard of self-defense? Everyone, right? So the legal definition, a person is justified in using force against another when, to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. What is this? How many legs does a chair have? Has anyone in here ever built a chair? You're number 17? Okay. When you're building a chair, do you start from the top?
Not necessarily.
Okay. What's the most important part of the chair?
Making sure that the legs are sound and in good shape.
Exactly. And so for self-defense, I want to focus on 4 words in there: reasonably, immediately necessary, and unlawful. So just like a chair, in order for someone, a defendant, to get self-defense, for you to believe that they were justified in using force, you have to find that it was reasonable, that the use was immediately necessary, and that it was in response to an unlawful act by another person. Without all 4 legs, you don't get self-defense, that chair falls. Does that make sense to everybody? Does anyone have any questions about that? Defense of property. Everyone here a Texas resident, born and raised? Who here has a gun? Okay. Are you allowed to use force to defend your property?
Yes.
And that's what the law says. A person in lawful possession of land or tangible movable property. When you hear the words tangible movable property, what does that mean to you? Car?
Furniture.
I'm sorry? Home? Number 36?
Yeah.
You said home?
Home.
Yeah, your home. You have an RV, if you have a motorcycle. Yeah. So a person in lawful possession of land or tangible movable property is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to prevent or terminate the other's trespass on the land, unlawful interference with the property. Does that make sense, everyone? So let's say you see someone come onto your property, they don't have the right to be there. Can you use force to get them off your property? Yes. Let's say you have a bicycle and it's on your land, or let's say it's not on your land. Let's say you have a bicycle and someone is on your bicycle, you come out the store and you see someone riding on your bicycle. Can you use force to get them off your bicycle? Does anyone have an issue with that, with someone being able to use force to protect their property? Voluntary intoxication isn't a defense to the crime, so you can't voluntarily drink or do drugs and then say, oh, it was the drug that made you do it. You're still responsible for your actions. Does that make sense to everybody?
Yes.
Does anyone have an issue with that? So this is a slide that I always use, and then maybe like a year ago, one of my partners was like, I don't want to be robbed anywhere. But the reason that I ask it is it'll make sense. So would you rather be robbed here, and the picture is like a dark alley, or here, and that is Spurs game? Someone have your number, yes, sir. 13. Where would you rather be robbed?
I wouldn't want to be robbed at either place, but definitely in public would be better than a dark alley.
So yeah, he said he wouldn't want to be robbed in any place, but in public would be better. Why would in public be better? Your number 29.
Because once they rob you and took whatever it is that they want, more than likely they would quit and flee.
Okay, they would flee. Thank you. Anyone else have any other? Your number 23.
Witnesses?
Witnesses. Yeah, anyone else? Your number 27.
Because there's a chance that someone in law enforcement may be at that particular location that would be able to assist you.
Yeah, so you'd be, because who chooses where a crime happens? Is it the victim or the defendant? Does everyone agree with me that it's the defendant who chooses where crime happens?
Yes.
And so obviously you would want to be robbed at the Spurs game because there's lots of witnesses. They can say, okay, it was that person who did it. But let me give you an example. And I want to tell you what the law is. The law says that only one witness is required to prove up the case. If we bring that witness to you, that they take the stand, they swear to tell the truth, and you believe that witness, you find that witness credible, and you believe that they proved all the elements to you beyond a reasonable doubt. And so, example, let's say you're in that dark alley. Let's say someone robs you. You see the person, you get a good look at him. You go to the police, and you're like, I know who robbed me. It was Joe Smith. And they're like, well, was there anyone else around? They're like, no. Were there any cameras around? No. Did you have fingerprints or anything like that? No, but I know 100% sure it was Joe Smith. I recognize him, I knew him from the past. And then the officer's like, well, sorry, I can't do anything for you. Is that right? Is that fair? Yeah. And so because situations like that happen, because it's the defendant who chooses where crime happens, the law says that if we were to bring you just one witness and they prove all the elements to you beyond a reasonable doubt, that that's sufficient. So the question is, does anyone have a problem with that law? That they feel that that one witness isn't enough to prove up a criminal offense and that they would need additional evidence, whether it be more witnesses, whether it be video, fingerprints, whatever. This is juror number 23. Yes.
No. I get the idea of the credible, but I do personally believe that it should be more than one, or there should be a additional.
Your Honor, I'm not able to understand the juror.
All right, juror number 23, if you
Yes.
could just speak louder. Everyone, pretend like you're at the family reunion or at a picnic and you've just seen a long lost relative and you're shouting across at them. So that's the type of booming voices we need so that everyone can hear.
No, in my personal opinion, I believe that while one credible witness could be sufficient in personal belief, I believe that there should be other items or other footage, another person, someone available to give that, or to trying to think of the right word for it, but to pretty much agree with what's being said, that you need more than one view.
Yes, ma'am. And so just to follow up a little bit, so even knowing that the law says only one witness is necessary, you're saying that you would still need more than that?
Yes, I understand. I just, I know myself personally, that's how I view on most things is that it needs to be more than one.
Thanks for honesty. See, if you disagree with me, nothing's gonna happen. So does anyone else agree with your number 23 and feel that person that they would need more than just one witness? Your number 26, do you feel that same way?
Yes, sir.
Your number 18?
If there's no, like, if there's no physical evidence of, like, if somebody says, oh, he flashed a gun at me, and nobody else was there. Is it possible this person's lying?
Well, and so let me go back to the purpose of everything was that you believe that witness. So you find it credible, you believe that they prove all the elements. So you don't have any doubt about them lying. You believe everything that they're saying.
I'm sorry, you're gonna have to stand up.
Well, then again, if I believe the witness, then that wouldn't be a problem.
Okay. So once that's been cleared up, does anyone else still have an issue with the one witness rule, what we call it? Juror number 19?
I guess I would say I'd be very skeptical unless there was some surrounding support, like the person knew them. But just a random person, eyewitness accounts are very unreliable.
Thank you. And juror number 31?
Yes, I also agree. I wouldn't convict on just one person's testimony. I think that there's a lot of, I guess, you just need some sort of corroborating evidence to show something other than one person's testimony or opinion.
Thank you. Anyone else? Juror number 4?
I think what it comes down to is we're looking at two different sides, right?
There.
We're looking
Can
at.
you go to the microphone? So there. Thank you. Please.
I think I can understand and relate with everyone because we're looking at two different sides, right? We're not just looking at the defendant or the one that may have caused the crime. So with that in mind, it's going to come down to if it's just one witness, maybe we do believe that one witness, but at the same time, we want to take that other person into account, right? Just to see, the evidence is there before you convict somebody. I think that's.
Okay. And just, I want to make sure that the judge asked earlier about the defendant's right to not testify and everything, but you're not saying, or are you saying that you would need to hear from the defendant, you would need to hear from the other side in order to make a determination?
I need to see it all, right? Before you make that determination. And I think when you're saying, are you okay with that one witness? Maybe you are, but you have to hear it out and make sure you have the evidence.
So
I didn't hear the last part. Make sure you have the evidence. Yeah.
before you make that decision. And so let's say that we were to bring you just one witness, that you believe them, you believe that they prove all the elements to you beyond a reasonable doubt, but you don't hear anything from the defense, from the defendant or any type of evidence from the defense. What would you do? What would your verdict be? Would it be guilty or not?
Your Honor, I object, trying to get the witness to agree to something that they should not be agreeing to. Try to bind them.
All right, I'll sustain the objection. If you can just ask your question another way, State, please.
Who would you hold it against if you don't hear from the defense?
I wouldn't hold it against.
So if you only heard from one witness and you believe that witness beyond a reasonable doubt, would you be able to find the defendant guilty?
If I believe them, beyond a reasonable doubt.
Okay, thank you. Sorry, I know it took a bit. Did anyone else have an issue with the one witness rule? So types of evidence, I talked about this earlier, that comes from the witness stand. So anyone who takes the witness stand, normally there's a witness stand, it will look like that. They swear to tell the truth, that's evidence. Now, it's up to you whether you find them credible, whether you believe them. That's one of your roles as a juror, is to weigh the credibility of the different witnesses. Type of witnesses that you can expect to see from the victim, from police officers, from eyewitnesses, etc. Other types of evidence that you could possibly see, videos. There's physical evidence. So in the robbery example, there may be a gun, there may be fingerprints, there may be a getaway vehicle. All of that is evidence that you would consider when you're reaching a verdict. But does everyone agree with me that all of that, based on what we just talked about, all of that isn't necessary in order for the state to prove a case, to prove a case to you beyond a reasonable doubt? Or does anyone think that they do need all this stuff? Now that you see it laid out, you're like, yeah, you know what, I do need. Okay. Yes, ma'am, juror number 78.
I just feel that there should be some type of physical evidence and that just someone's word wouldn't be substantial enough.
Okay. And even if you believe that person's word and you believe that they prove all the elements to you?
Yes.
Thank you. Anyone else? Juror number, what's your number?
45.
45?
I just have a question on the one individual rule. You're saying that you're going to convict a person on the testimony of one individual?
The law says that if a jury, you're on the jury and you find that one individual credible, yeah, so no concerns, you don't think they're lying, you believe that they prove all the elements to you. So in assault, you believe that they actually punched or kicked or did whatever to that person and that they caused bodily injury, and you're convinced beyond a reasonable doubt, then yes, that's sufficient. Do you have an issue with that?
Yes, I do.
Thank you. Juror number 1.
In this particular instance, is the one person that is the witness also the person that has been assaulted?
Yes.
Okay.
Did that affect your answer?
Can you repeat that, please?
Yes, he said, so if the witness is the victim in the case, is that still enough, basically, right? Is that what you asked?
Yes, that's what I asked.
Okay.
All right, if we could pause for a moment. This is the question. The law is that if the state proves their case beyond a reasonable doubt with one witness, whether or not that will be enough for you. So in order to get to that point, if the state were to present only one witness, you would have to believe that that witness is telling the truth, and you would have to believe that they proved every element that the state has to prove. So the question is whether or not in those circumstances, would that be enough for you?
In that case, yes.
Well, that's it. And so I'm going to restart your time, State.
Thank you, Judge.
Makes sense.
Okay, sorry, I wasn't meaning to interrupt, but I appreciate the judge explaining that to y'all better. So, does everyone agree with the judge? The example, the way that she explained it, that you would be okay with finding the defendant guilty based on one witness? Do the people who earlier raised their number, does anyone change their answer, or do they still feel the same way? I guess, is there anyone who changes their answer? No.
I don't agree.
Okay, juror number 8. Juror number 31.
I would certainly take the circumstances into account, in the context, but I do know that eyewitness testimony even has been shown not to be credible in a lot of cases. There's a lot of research to back that up. So I would definitely want some form of corroborating evidence or, something to make it a little more solid than just one person's testimony, but I would take the context, of course, into account of what was being said.
Thank you. Juror number, forgot your number, sir.
19.
19. Yes.
I haven't changed my mind in terms of what I said initially is, as the other person said, eyewitness testimony is generally unreliable, but in some circumstances, very narrow circumstances, it might be acceptable, but most of the time, for instance, in your example, if someone got mugged in a dark alley, and the victim fleetingly saw the patient, the person, I wouldn't believe that. I wouldn't believe it.
Thank you. Juror number 23. Is your answer still the same or has it changed?
Yes, my answer is still the same.
Thank you. And juror number, can't see your 79,
78. Mine is still the same.
78 still the same, 79.
I understand the judge's clarification, but if there is one witness and that witness is the victim and there's no physical evidence, I just feel, obliged to say that that would not be enough for me.
Thank you. And juror number 26.
I'm in the same boat. He just spoke.
Okay. Juror number 59.
I can't see
Sorry.
you or hear you.
Everyone, please remember to go to the microphones because no one can hear you. So it's very difficult for the court reporter to hear. Brenda, could you raise your hand, please? She is taking down everything. In courtrooms, if the court reporter can't hear you and doesn't take it down, it did not happen. So she needs to record everything. So everyone, you see how loudly I'm speaking? It's okay to speak that loudly.
I agree that more witnesses would be needed in order for, as far as for me, for credible.
Did you say you agree that more witnesses would be needed for you? Thank you. 64.
Aside from all the other people's answers, tying that in, I would also have to say that just the sole fact that one witness being the victim, it's kind of hard to completely side with that one person because one, misidentification is always happening. People are always being sent to prison, wrongly convicted, as well as people backtrack on their statements, whether it's, oh, well, he didn't mean to, and then it's all of a sudden, no, he did this. And it just goes back and forth. So you kind of need more than just one witness, maybe not just the witness itself, maybe a little bit of evidence to tie into it, but it's kind of hard to make a full decision on something that could change somebody else's life completely based off of one person, especially if it's the victim itself that is being the witness.
And so everything you said, even assuming, let's assume that you believe the witness, you still say that that's not enough.
Even if I believe the witness and
Beyond a reasonable doubt.
yes, if say I believe the witness beyond a reasonable doubt that their trauma and what they went through is correct.
Hold on, repeat that.
Can you repeat that?
Even when I believe the witness beyond a reasonable doubt that their trauma and what they went through is completely real, I still have to consider the fact that a lot of people get wrongly convicted over misidentification solely for the fact that they didn't have DNA to prove that it was solely them. And aside from that, DNA gets messed up so much that people, even getting tested for DNA, they still get wrongly convicted for it.
Okay, thank you. Anyone else? Your number 48.
I agree with what everybody else is saying. Yeah, I would need more proof.
Okay, thank you. Your number 32. Could you go to the microphone? Sorry.
I agree with everyone else as well.
Okay, thank you.
What was your
Anyone else?
32.
75.
I just believe that there should be multiple elements to make a deciding factor. One single factor, while it could, whether it be a single witness or physical proof, that is more than likely sufficient, but there should be multiple, whether it be multiple witnesses or supporting physical evidence with the witness to support the same decision. So that way it's makes sense.
Yes, sir. So in an ideal world, there would be victim testimony, eyewitnesses, DNA, fingerprints, video cameras, everything. But your number, what was your number again?
75.
75. But let's go with the example, the one witness rule. And so you only have one witness, but you believe that witness, you believe they prove all the elements beyond a reasonable doubt. So you have no doubts that they prove all those elements. So yes, it was that person who committed the assault.
I would believe that as likely, but it's not 100%.
Would it be, but if you're convinced beyond a reasonable doubt, are you saying you can't be convinced beyond a reasonable doubt?
I can't be convinced with a reasonable doubt.
Thank you. I can't be convinced beyond a reasonable doubt. Anyone else? Let's get this question. Have you, a close friend, a family member, ever been arrested, charged with, or convicted of an assault type offense? That applies to you. If you raise your card, your number 1, your number 9, your number 18, 33, 7, 32, 46, 48, 51, 57, 15, 23, 60, 64, 72, 75, 65, 76, 78, and 79. 5. Your number 44 also, and your number 12. Okay. And normally I would sort of ask each of you in a little bit more detail, but ultimately the question and what we're trying to get to is whether the person, whether it was you, whether they were charged, whether they're the victim, I guess anything about that experience, that assault, would that affect your ability to be fair and impartial to both sides in this particular case? So, people who raise their cards, anything about the experience that you had, and if you still raise your card, and I will have more follow-up questions for you. But is anything about the experience that you or that close friend or family member had would affect your ability to be fair and impartial in this case? Your number 5?
No.
No? Okay. And your number 14?
Yes, because my daughter's been assaulted.
Okay. And I guess the question is, you would hold it against the state or the defense?
I don't know. It's just a personal, emotional thing for me.
Would you be able to separate your daughter's experiences from this particular case, or?
I don't know.
Anyone else? Your number 78.
Yes, I had a very close friend of mine who it was self-defense, but got charged with assault, and ultimately he ended up going to prison for 10 years when it was a wrongful conviction in my and that up against the state, you know, and their evidence against him.
So based on your friend's experience and what you know of it, will that affect your ability to be fair and impartial in this case, even though it doesn't involve the same people? Would you be able to listen to the facts, the evidence that's presented, and make a verdict solely on that, or would that past experience, that past knowledge that you have affect your ability?
I think I could be impartial.
You think you can be impartial?
Yes.
Thank you. Anyone else have your number 79?
Yeah, so 2 weeks ago, my nephew got charged with an aggravated assault with a deadly weapon in Atlanta. So I'm currently working with him and his lawyer to get him out of it. So if I'm being completely honest, I'm definitely going to be thinking about my own nephew and how he was defending himself, but how he's now being charged, but as attacking someone who randomly assaulted him on the street. So whether or not that's going to affect my decision to be unbiased, I can't say for sure, but I can definitely say as I'm sitting back here now, I'm thinking more about my nephew, I'm being honest. Because it's soon, it's related, it's interesting, so.
And so, sort of answer, but I guess I want to ask, sort of clear it up. So even though obviously this is your nephew, same people aren't involved.
Right.
Would you be able to render a verdict based solely on the facts and the evidence that are presented to you if you're chosen on the jury? Or would your nephew and what he's going through, would that affect your ability?
But that's what I'm saying. I think there's a very high chance that it's going to affect me, because I'm thinking about my nephew and how already things are being thrown at him that are just not true. And I know he defended himself. And then here I am with another aggravated assault. And I'm already thinking this guy's probably was defending himself. And we haven't even got to the point where we're talking about evidence. So I'm just sharing, I'm just being honest and upfront.
Yes, sir. Thank you. Anyone else? Your number 60.
My father was charged with aggravated assault and went to prison.
Your Honor, I can't hear it.
My father was sent to prison for aggravated assault for almost my whole life. But if the evidence, I'll listen to the evidence, so I would be fair.
Okay, you would be able to be fair?
Yes.
Thank you. Anyone else? Your number 72.
Yes, I currently have two family members being charged with the same, and I don't think I could be impartial to anything right now.
You said you don't think that you can be impartial?
No.
Thank you. Did I miss anyone? 75?
Yeah, if I had to be honest, I probably could be impartial. However, me as a victim, the assault that happened was from my brother, from my family member. So with that, it's just with the history that he's had. And that's where I was going by earlier when I was mentioning about facts, just, that there's multiple elements. Part of me would say, there's the family aspect and, the support, but also too, at the same time, there's also the logical factor. And there's just some stuff that, yes, there's statements, yes, but also there's proof as well. And there's also history and there's multiple things to account for. So for me, I'm impartial, but there's multiple elements for me to come to a firm decision, which, yeah.
Would you be able to render a verdict based solely on the facts in this case, and not what happened with your brother?
More than likely, but because I've been through it before, it can easily, it can affect it. I could see it being affected.
Thank you. Anyone else? Do you know someone who you believe has been treated unfairly by the criminal justice system? Anyone who didn't respond last time? 64?
I have an uncle who was in the military pretty much all his life. And while being in the military, one of his platoon mates, I don't know what they call them, was sexually assaulted. And he put his hands on the person who was assaulting her and beat the crap out of him. And he ended up being arrested and charged for protecting this young woman who's being assaulted, and ended up going into the prison system. And then after being released later on, got charged for something that he was no longer in the city, wasn't there to begin with, but he got charged for it and ended up going back to prison again, and ended up consistently staying in the prison system for wrongful convictions.
And so, because of your uncle's experiences and what you know about them, do you think that that'll affect your ability to serve on the jury?
I don't think it would affect my
my unbiased opinion or whatever for this jury specifically, because it was a special case for him in the sense that when it happened, the military was not very big about sexual assault cases and providing women with the outlet to express it. They're not very big on doing it now, but even then when it happened, it wasn't good.
Did you say it wasn't good?
Yeah, it wasn't good.
Thank you. Anyone else? So have you or someone you know, a lot of these questions I used when I first started off, and I sort of think of it like most people, or a lot of people have had a negative experience. But have you or someone you know have had a negative experience with law enforcement that you think would affect your ability to be fair and impartial in this particular case? Anyone? Is anything that's going on socially right now with the climate that we're in, does anyone think that what's going on with that would affect your ability to be fair and impartial? Is anyone uncomfortable sitting in judgment of another for religious, moral, philosophical, any type of reason? So if you were chosen to be on this jury, you would be unable to find the defendant guilty because you feel that it's not appropriate to judge someone else or something of that nature. Does anyone have that feeling or belief? So skipping this is about punishment, and the defendant elected to go to the judge for punishment, and I believe everyone said that they're okay with still serving on the jury, even though they won't get to decide punishment if the defendant is found guilty. Is that correct? Last slide. Is there anything else that you think we should know that I didn't ask you about, that didn't come up, but you think would be important for deciding or trying to figure out if you would be fair and impartial, a good juror for this case? Okay, well, I thank everyone. Thank you for your time.
All right, everyone, we're going to take a 10-minute break to give everyone a chance to walk around and stretch your legs. So if everyone can be back here at 11:50, everyone please rise for the jurors.
Exactly, that's what my fear.
All right, everyone, please be seated. We can't begin until all the jurors are back here, so we're missing a couple of jurors. All right, I believe everyone is here. Mr. Young, yes? There's one missing? All right. All right, thank you. Deputy Laura, do we have everyone? Do we have everyone? All right, does anyone notice anyone who was your next door neighbor and they're not next to you now? Okay. Usually pre-COVID, I would tell everyone, look to your left, look to your right. That's your next door neighbor. Make sure they come back the same time you do. But I'm going to turn it over for voir dire to Mr. John Young. John, you may proceed.
Thank you, Your Honor. Okay, let's see. Now, can everybody hear me?
Yes.
Okay. Now, usually I'd be dancing around here, but you can't. I have a microphone here, but candidly, it's just more trouble than it's worth. So I'm going to go ahead and try and do it from here. There are just a couple of things. One, we got really hung up on this one witness rule. And we spent a lot of time talking about that. But what I'm going to ask you to kind of follow a path toward that decision. It doesn't matter how many witnesses are put on. The issue is, do you find an element of the charge proven beyond a reasonable doubt? It doesn't matter whether the College of Cardinals and the Pope all testify to something, or a 13-year-old child testifies to it. If you believe that person's testimony beyond a reasonable doubt, then that's when the one witness rule comes into play. We're saying that the first step is, were you convinced? Is this true? Okay. What does beyond a reasonable doubt mean? There's three parts of it. Beyond a reasonable doubt. And that's all you have to do. Is it beyond reasonable and doubt? Three things. All right. What does beyond mean? What does it mean? Anybody? Go ahead and answer. You have to get the microphone. Show me your number. Court reporter needs to take it all down.
62.
62. What beyond mean?
Beyond goes further.
Goes further than. Okay. What does reasonable mean? Anybody want to? I would say reasonable means it's not fanciful. It's not. I was told when I was a child that the moon was made of green cheese. Is that reasonable?
No.
No, it's not. Okay. So beyond a reasonable doubt, if you can find that you do not have that reasonable doubt and you believe what's told to you, is that beyond a reasonable doubt? Does anybody disagree with that? And since it's your definition of it, because as the judge said, we've basically been cast adrift on this. Used to be we had a definition, but Supreme Court said that's not what we're going to use anymore. So now, once we've decided that something has been proven to me beyond a reasonable doubt, those three words, is there anyone that would not accept that proof if it was proved to you by only one witness? I would ask if anybody is going to hold us to a higher burden than that to raise your number. There are no numbers raised. Now, it has been mentioned that there are several different standards for beyond a reasonable doubt or for criminal cases, but you have to look at all the different kinds of cases that come before the court of law in the United States. There could be something that they merely have to prove a preponderance of the evidence. Can you guess what that involves? Money. A civil lawsuit has to be proved by a preponderance of the evidence, more likely than not. Okay. If the state wants to take your child away from you, they have to prove to the court by clear and convincing evidence that that's the right thing to do. Okay, that's a higher standard of proof. And then we ultimately get to the highest standard of proof in the law, beyond a reasonable doubt. Now, I was a history major in college, so I go back to where these things come from. Why in the world do we have jurors in the United States? Why? Why do you think? Anybody? No? Because most of the founding fathers of the United States were involved in basically somewhat nefarious activities, but they were certainly rebels. They were certainly treasonous, but they were also usually involved in smuggling and some other things. But they wanted a group of their peers, people that understood the social milieu that they were involved in, that they lived in. They wanted you to take a look at the facts and decide whether a person was guilty of something or not. That's why we have jurors in the United States. It's been addressed many times as flawed, and it is. Because we can only do this if you're honest with us. That's the only way this works. Now, the only saving grace for this flawed system is, as has been said about democracy too, it happens to be the best we've found. And one person said, well, but there are sometimes people who have been found guilty and later physical evidence proves that they were innocent. And that's going to happen. That is going to happen. But this system requiring 12 people to come together and reach a unanimous verdict has proven itself again and again to be the most likely system to arrive at a correct verdict. When the trial is over, we put our evidence on, we've given, the prosecution and I have given you our interpretations of that evidence. And you're getting ready to go back to deliberate. And they're going to tell you that you can't discuss the case until then, because that's when the judge will give you what's been referred to as the jury charge. It's a roadmap. It's a list of all the rules, what the elements of the charge are, what evidence you can consider and what not to consider. And it tells you how to physically make that decision. That's why we call it the deliberation room that you go to. Now, my wife likes to read mystery novels. And when she's reading a novel, she'll be, 100 pages into it, and she'll get all excited. She knows who did it. And she goes to the back of the novel to look and check. You can't do that here. If you can't wait until the end of the book to get all of the facts in front of you, you can't be a good juror. Is there anyone that would not be able to wait to make that decision until they've discussed it, deliberated with the other jurors? Thank you. Now, the term elements of the offense have come up several times. And that roadmap the judge is going to give you will list the elements of the offense. When you get that, there's going to be a lot of other evidence come in the course of a trial. There always is. And there may not be, if the charge is, did you rob the bank? And there may be some evidence that the car is either green or blue or red or yellow. And you're wondering, what does that have to do with anything? Well, And unfortunately, the prosecution goes first on these things. The trial is going to be run the same way. They'll put their evidence on first. In fact, they'll make their opening statement first, and then the defense will. They'll put their evidence on. And yes, I get to cross-examine people, but it'll go back and forth. And when they're finished putting their evidence on, that's when the defense will put its evidence on. And then we'll get to the end of the trial and we'll have arguments. And the prosecution has the burden of proof, so not unreasonably, they have the option of speaking first and last. And again, factors into, are you able to wait until the end of the presentation to start making a decision on what do you think is best? They're going to tell you that in the charge that you should not basically be hard-headed. If you are there and you listen to the other jurors, that's what they mean by deliberate, you talk together, because some people may notice some things that others don't. If you can reach a verdict, you're supposed to try to, because it has to be a unanimous verdict. But at the same time, if you can do that, you should do it only if it does not offend your firmly held conviction about what is the correct verdict. Is there anybody who can't do that? All right. Marcus gave a very nice presentation. He unfortunately got first and he got all the good questions. And I have no further questions. Thank you.
All right, thank you. Ladies and gentlemen, what I'm going to do is I'm going to have you step out of the room. Then we will let you know which one of you have been selected to be on this jury panel. So if you will all rise, and I'm going to need everyone to wait outside. Yes, they're going to stand at that microphone right there.
You're gonna bring them up close to it?
No, they just stand at the microphone. Excuse me, juror number 8. Hi, both sides may have a few questions for you. If you could remember to speak up loudly and if you could stand at that microphone, please.
Oh, I thought we were gonna do them all at the same time.
No.
No.
All right.
We're gonna go back to the one witness rule one last time.
That's fine.
Okay. So put everything in your mind about, I would like this, or I think that. Everybody wants more evidence. I want more evidence. The question is, if a person testifies and you are sitting there listening to them and you believe them and they prove every element, the law says you must find them guilty. But you are entitled to, as a person, say, I can't do that. So the question is, can you follow the law in that scenario, or do you say, I just can't do that?
I don't think I could. Me personally, I don't like to judge. I don't pass judgment. I leave that up to God. But if I had all the evidence in front of me and it was credible, I mean, I think I would doubt myself if I agreed to that one witness rule.
Okay.
That's just me.
And I'm gonna ask to take just a little bit more from you. It's gotta be yes or no. So not, no, I think you can follow that rule, you can't.
No, I couldn't.
Thank you, ma'am.
You're welcome.
I pass the witness, Judge.
All right. Defense.
No question, Shirley.
All right. Thank you, juror number 8.
Thank you, ma'am.
I wait back outside.
Yes, please. State.
Pause.
Defense.
Okay.
All right, that'll be granted. Number 8 for cause. Deputy Lawyer, if you could bring in juror number 19, please.
So that puts 33 in play. So really, we're only able to do this 3 more times.
14.
Oh.
All right, juror number 19, if you'll please stand at that microphone and remember to keep your voice up.
Sure.
Both or either party may have more questions for you. State.
Thank you, Judge. Mr. Elledge?
Yes.
Okay, we're gonna return to the one witness rule one last time.
Okay.
So I need you to put aside anything that you might think about the hypothetical questions. The goal is not to outthink the problem. The goal is to stay within the confines of the hypothetical and just answer that hypothetical. That is, a person takes the stand, they are a witness. They testify to every element in the crime. They provide evidence that you believe and find completely credible beyond a reasonable doubt. At that point, you would be given a jury charge that instructs you that if you find those things, and in this hypothetical, I'm telling you, you do find those things, you must find the person guilty. However, as a person, you can say, I couldn't do it. I can't believe in that. The fabric of my being doesn't believe in that. So what we need is a final yes or no answer in that hypothetical scenario, bringing in no other variables of your own. In that scenario, with what the law says, would you yes, follow the law, or no, you can't do it?
No.
Thank you, sir. Pass the witness.
Defense. Excuse me, sorry. The defense may have some questions for you.
No question, Shirley.
All right, thank you.
Thank you, sir.
State to juror number 19.
Cause.
Defense.
Okay.
All right, that will be granted. Deputy Laura, can you bring in juror number 23, please?
Who's 23? What was it?
Yeah.
You had that one?
She's the first one.
Oh, yeah. Could you just go over the microphone and stand on the blue dot, please?
And please keep your voice up. One of the defense or either state may have questions for you. State.
Thank you, Judge. One more dance on the one witness rule, okay?
Okay,
And it needs to be a yes or a no.
okay.
And don't think about any other facts that you might like or could like. Everybody wants more evidence. Just think about what's in the hypothetical, okay? A witness takes the stand. You sit and watch all their testimony. Everything they say proves every element of the offense. You believe them beyond a reasonable doubt. You find them totally credible. At the end of that, the judge gives you the law and it says, If you find all those things, which in this hypothetical you do, you find them guilty. So yes, you can follow the law, or no, as a person, just the way I am, I can't follow that rule.
No.
Thank you, ma'am.
All right, any questions for, just one moment?
second.
Any questions from the
I
defense?
passed, Judge.
No, Your Honor.
All right, thank you.
Thank you, ma'am.
State,
Cause.
defense.
Okay.
All right, that'll be granted. Deputy Laurie, if you could bring in juror number 31, please.
So we get up to what right now, Judge? 35 or 36? 35 more?
We shall see. In this court, I do alternates. Just one moment. Juror number 31, if you could stand near the microphone in the center, please. State and defense may have some questions for you. State.
Thank you, Judge. One last time for the one witness rule, okay? And don't think about, I read this book one time or I watched this special. Don't think about facts you'd want or should have. I'd love more evidence on every case too. Just confine your answer to the hypothetical, all right? And then I have to ask for a yes or a no at the end of it. And the hypothetical is, you're ready to go, I know, but let me do the.
Ask for clarification.
Okay, go ahead.
Go ahead. No, go ahead. That's
Okay.
the opportunity.
You're sitting in the jury box. One witness takes the stand. You are getting to watch everything they say over the period of, their testimony. Everything they say proves every element beyond a reasonable doubt. You're not left wondering. It is in your mind, you go, this is beyond a reasonable doubt. You find them credible and you find everything they say believable. And then the judge gives you the law and it says, if you find all these elements and that person was credible, you shall find them guilty. So yes, you could do that, or no, just because of who you are, you just couldn't do it.
Is it all I can say is yes or no?
Yes. Although you're going to ask your question before you answer.
I sort of wanted to make a statement about
Sure.
what you're saying. I feel like a witness can be credible
Mhm.
without being right.
Okay.
Okay, so I feel,
That's-
is that too much? I'm sorry.
No, if you could just speak louder, please.
Oh, okay. I feel like a witness can be credible without being correct. So,
yes, ma'am.
yeah, so a person, I believe a witness will believe what they say is the truth wholeheartedly. So if what you're saying is, I'm not sure if this is a legal term, like to be credible means you're truthful and you're honest and that means you're right. And that should be evidence, or if me as a jury has to take into account the situation, as a juror has to take into account the situation that memories are fallible, witnesses make mistakes, people can have their memories influenced by unintentional insertions of things. To me, one witness to find a person guilty, if that's what you're asking, in any situation, even if I feel like that person truly believes what they're saying, truly believes the evidence that they're presenting, which I would agree with, I could not
Okay.
find someone guilty.
You're
based
kind of
on-
adding an element.
Okay,
You
I'm sorry.
believe them. You
I
don't go.
believe they
you-
believe what they say.
No, I'm telling you, you believe them. Because you're adding an element here. I'm not telling you, you're saying, I think you it's not an auctioneer or a horse trader. You believe this person. You are sitting there. Hope I don't do Woolsey,
Woolsey.
Miss Woolsey, you are believing them. You go, I am believing this story. But all I have is this one witness. Can you follow the law, or would your DNA still make you go, "Ugh, I just can't do it"?
I think it's a slight misrepresentation of what I'm saying. I believe that the person is not lying in the sense that they believe what they say. Would I believe what they say?
You would not.
I don't think so. With one witness for one piece of evidence.
Okay,
No.
that answer could be sufficient, but it's got to be yes or no.
In terms of what was your question again?
You,
Would I-
you believing them for the case to be sufficient.
No, I would not believe them. And I would not believe it would be sufficient evidence for the case.
Okay. Okay. Then Judge, I pass on that.
Defense.
Okay. It sounds like what you're saying is that they believe what they're saying to you, correct? Okay.
I'm just wanting to clarify that I don't think that a person is necessarily uncredible if they're wrong. You know what I mean? I wouldn't consider them a bad witness or a bad person or untruthful. They could just be mistaken in what they believe.
Well, they are actually a bad witness if they're wrong. But, see, it's not the issue of what they believe. If you have this fact, say one element of the charge of jaywalking, did this person walk into the street not in a crosswalk? If somebody testified to that fact, that would be an element of the charge in that misdemeanor charge.
Right.
And since, unlike Jay Leno, we do not have our lives videotaped. There's no other evidence to prove either yes or no when that happened. So at some point, we just have to accept what witnesses tell us. And that's why we have the one witness rule, so that if someone comes in and the deposit that the prosecutor already made to you was that you believe the person. If you believe them, not if you believe they believe themselves, but if you believe them, how are you going to vote?
In a trial situation, there's two sides, right? So there would be another side saying, that's not true.
Doesn't have to be.
I didn't do that. They didn't see me. I was somewhere else. I didn't do that. And with one person, no other evidence than one person's report, I would not take that as sufficient evidence. I would need some other, I would actually say that case probably shouldn't have been brought to trial on one witness testimony with no physical evidence of a crime.
No further questions, Juror.
Sorry.
All right.
Nothing. There's no wrong answer.
No.
Thank you.
Thank you, Judge.
Thank you. I appreciate your time.
Thank you.
Stay.
Call.
Object.
I'm going to sustain the objection. I'll grant their challenge for cause. I'm going to grant their challenge for cause. All right, thank you. All right, could I see juror number 32, please? All right, if you could stand at the microphone, please keep your voice raised and state.
Hi. Ms. Orozco? Okay, we're going to talk about the one witness rule one last time, okay? And I kind of saw you like nodding along with some of the other jurors when they were saying it. So don't think about any facts you'd like to have, you'd want to have. Just listen to the hypothetical and you have to answer yes or no based on just this hypothetical. It's just the way the law works, okay? You're in the witness, or excuse me, you're in the jury box and you're getting to listen to a witness testify, all right? You get to listen to all their testimony asked by both sides. At the end of their testimony, they have proved to you beyond a reasonable doubt each element of the case, and you believed them, and they proved it to you beyond a reasonable doubt. The law then would instruct you that is enough for you to convict on that one witness's testimony in those circumstances. Could you, yes, follow the law, or no, just because of who you are, you say, I just can't do it?
It would depend, I suppose, but if I had to follow the law, then yes.
Okay, in that scenario, your answer between the yes and the no would be a yes.
Yes.
Okay. Thank you. Judge, we pass the witness.
Thank you. Any questions, defense? All right, thank you.
Thank you. That was 32.
State.
No.
All right. Are you withdrawing your request for cause on that juror? All right, then bring in juror number 48, please.
Are we that high, Judge? What about?
Yes. No, we're just going to go through all of them.
But are we going in order?
Yes, this
Okay.
is the order. And then the other witnesses for the bias will be on another issue.
Okay.
All right, juror number 48, if you could stand at the microphone and keep your voice up. The state or the defense have some questions for you, state.
Okay, sir. One witness rule, one more time, right? Don't think about the facts you would want, you might want. You don't come up with the scenario. It's kind of a weird thing, but you just have to listen to this hypothetical and just answer this hypothetical, but with your answer, okay? That is, you're a juror. You're sitting in the jury box. You are listening to one witness testify. That witness tells you the story, and that story proves to you, you believe them, it proves to you every element of the charge. And it proves it to you beyond a reasonable doubt. And you find that person credible. The judge then would ask you, could you find the person guilty? And the law says that one witness, if you believe all these things, and I'm telling you in the hypo you do, the law says that's enough. So yes, you could follow the law, or no, just because of who you are, you could not follow the law, even though you understand it. And there are no right answers, and there are also no trapdoors. So but it's important you get it right. Oh, sorry, it's important you be honest.
Right.
Bad word.
Yeah, okay. You know what, I'd have to say yes.
Okay. So you could, in that scenario, you could follow the law.
Yes.
Okay, all right, thank you.
All right, thank you.
All right, just one moment, please. Defense, any questions?
No questions, Your Honor.
All right, thank you.
Thank you.
State, with regards to juror number 48, are you withdrawing?
Withdraw.
Deputy Laura, could you bring in juror number 59?
Do we have to go that high? We're gonna do everybody?
Yes. All right, juror number 59, if you could step up to the microphone and please keep your voice up. State or defense may have questions for you, state.
Yes, ma'am. Ms. Williams, we're gonna talk about the one witness rule one more time, okay? And so don't think about any facts that you want or you like, or I wish I had that. You have to just listen to just this hypothetical. And it's for the lawyers. For just this hypothetical, we need a yes or a no answer, okay? No wrong answers.
Okay.
You're a juror. You're sitting in the jury box. You're listening to one witness testify. It's the only person that testifies. And you get to listen to all their testimony, and their testimony proves to you, it proves to you each element of the offense beyond a reasonable doubt. And you find them credible. You find them believable. At the end of that, the judge would ask you to find them guilty or not guilty. And the law says that is enough to find them guilty. So yes, you could do it, or no, just because of who you are, you couldn't do it with just that.
I would have to say no.
Thank you. Pass the witness, Judge.
All right.
Questions, Your Honor.
All right,
Thank you,
thank
ma'am.
you. State,
Cause.
defense. The state is objecting for cause. All right, that'll be granted. Juror number 75.
Judge, what happened to 64?
Oh, I'm sorry. We'll
Do this one first.
we'll come back to 64. Hi, are you juror number 75 or 64? All right, juror number 64. The state or the defense may have some questions for you. Please keep your voice up. State.
Thank you, Judge. We're going to do one witness rule one more time. All right. No wrong answers, but we need a yes or no. And don't think about any facts you'd like to have, or that you should have, or that you want to have. Just listen to just the hypothetical for the purpose of the law, just a hypothetical, and it's yes or no on that hypothetical, okay? And here's the hypo. You are a juror, you're sitting in the jury box. One witness is on the witness stand, and they give their full testimony, right? They tell their whole story. You're listening to this person, and they prove to you, beyond a reasonable doubt, every element of the crime. And you find them credible. The judge will give the jury charge at the end of that, and the law says that if you listen to each element, you believed it beyond a reasonable doubt, and you found it credible, that you can convict. Or for this answer, yes, I could follow the law and convict. Or for you right now, no, I understand what you're saying, Tom, but I just, because of who I am or what I believe, the fabric of my being, I couldn't do that. So we need a yes, you could follow the law and convict in that scenario, or just no, you could not.
Yes, I could convict in that scenario.
Okay, thank
I
you.
think it was just a miscommunication. I wasn't understanding the question at the beginning when it was first
Okay.
brought to me.
And this is, you were 75?
64?
64. Okay, and then I guess just while I've got you, your prior experiences with the criminal justice system, was it your uncle?
Yes, my uncle, he was in the military for a very long time, and during that stay in the military,
So I remember the story. It's a moving testimony. It's a moving story. I just have to ask you a yes or no question for that, because that's personal, right? That's your family member.
yes,
Can you, yes, completely set that aside and be totally objective and unbiased in this case? Or no, it would affect you in some way during the hearing and emotions of aggravated assault case?
yes, I can set all of my emotions aside and put this as its own case and not drag anything else into it.
Okay, all right. Thank you very much. Pass the witness, Judge. I have no further questions.
All right, defense, any questions?
No questions.
Thank you.
All right, thank you.
Thank you.
State with regards to 64.
Withdraw.
All right. And Deputy Laura, if you could hold off from bringing in another juror, please. Yes. So we're going to go out of order. I'm going to call number 14 and have Deputy Laura bring 14 in for the bias question.
Because we don't have to do the 70s?
Yes.
Yep, no objection.
All right. Deputy Laura, could you bring in juror number 14, please? Yes. Thank you. No.
So at this point, none of these people were definitive. It hadn't been like hammered down. It was still like approaching the subject.
Juror number 14, if you could take a place at the microphone, please. The state or defense may have more questions for you, and if you could keep your voice up for me, that would be appreciated. Thank you. State.
Thank you, Judge. Earlier, you shared with us a little bit about the experience of your daughter. And the question from a legal standpoint that we have to ask you is, and it's got to be a yes or no answer, okay?
Okay.
Could you, yes, completely set that aside and be unbiased and fair in hearing an aggravated assault charge? Or no, it would affect you in some way in your ability to be fair and impartial?
No.
Okay, I pass the witness, Judge.
I'm sorry, I don't understand what her no is for. Is it no, it will affect her?
No, correct. No, she cannot set aside her emotions to be fair and impartial.
Is that correct? Juror number 14?
Yes, ma'am.
All right, defense, do you have any questions?
No questions, Your Honor.
All right, thank you.
Thank you.
Thank you.
State,
Cause.
defense.
No objection.
All right, we are going to
Judge, I think, can we do
take a
one more?
recess.
Can we just do 26?
Number
Marcus
26.
and I both had it, and I skipped over that earlier.
All right, and why would we be bringing
Same one
26 for?
witness, the one witness debacle.
All right. Deputy Laura, if you could bring in juror number 26, please.
Bree, do you have a button for the debacle? Mhm.
I said 26.
Yes.
26, 26.
Start using it over and over again.
Bob always used to get upset with me at 226 because I'd use words that weren't anywhere even. Yes,
Yes,
ma'am.
please. The state or the defense may have some more questions for you. State?
Yes, ma'am. How do I say your last name? Imber?
Ember.
Imber? Okay, we're gonna do the one witness rule one more time.
Okay,
Yeah,
got it.
and it's gotta be a yes or a no. And just to the terms of the hypothetical. Don't think about facts you'd want or should have or could have. It's just a yes or no to the hypothetical for legal purposes.
Got it.
All right. You're a juror. You're sitting in the jury box. You're listening at trial. Only one witness is called. This
Mhm.
person takes the stand. You get to hear their entire story, the entire testimony. As you're listening to it, it proves every element of the offense beyond a reasonable doubt. And you believe that person. At the end of the case, the judge gives you a charge that says that is legally sufficient to convict.
Mhm.
So yes, you could, or no, because of who you are and your beliefs, you could not.
I could.
Okay, thank you.
Any questions from the defense?
No questions, Your Honor.
All right, thank you.
Thank you.
told who the jurors will be. And the jurors from the list are number 2, 6, 11, 15, 17, 20, 24, 27, 30, 33, 34, and 35. The 2 alternates are jurors 38, 39. Any objections from the state? Any objections from the defense?
Okay.
All right, Deputy Lawyer, could you bring the entire panel back in, please? Everyone, please stand for the jurors.
Chairs missing. All right, everyone, please be seated. All right, first, I want to thank everyone for your service. The key thing to having a jury trial and the key thing that is needed for a jury trial are jurors. So I appreciate every one of you coming down here today. I know this is a different time and different circumstances, so we appreciate each and every one of you. I'm going to call the names of the jurors who've been selected. I will need you to remain seated. All of the jurors, you are excused and you will be allowed to get your parking valeted. You can enjoy the rest of downtown. It appears that we may have rain, but the temperature is nice. So whenever you think it's raining too much, just think it could be 105 degrees. One of my friends told me it's 109 in Arizona. So we are lucky. So the jurors who I need to remain are juror number 2, Laura Reitberg. And I promise I will learn to roll my R's. I'm from Louisiana, so I'm working on that. Oh, thank you. Juror number 6, Elvira Gonzalez. Juror number 11, Deanna Lopez. Juror number 15, Christy Cruz. Juror number 17, Albert Rock. Juror number 20, Jennifer Harris. Juror number 24, Sharon Denny. Juror number 27, Otis Scott. Juror number 30, Holt Beach. Juror number 33, Elena Carr. Juror number 34, David Dominguez. Juror number 35, Deborah Selena Cooper.
The alternates are juror number 38, Rebecca Garza, and juror number 35, Paul DeCoste or DeCosta.
Let's, Jimmy Judge, that's 39.
39, thank you. My ophthalmologist tells me, because I need my glasses for distance, but I don't need them to read. And he says, Stephanie, when you get tired of taking your glasses off, then you'll let me put the line in. So I'm still fighting that. All right, so everyone else, you are excused. Thank you so much for your service. And everyone whose name was called, if you'll just remain seated, please. Everyone, please rise. You too. Yeah.
Exactly.
At least one.
All right, everyone, please be seated. I know, he's on phone. And what numbers? Excuse me, juror number 5. If you could, yes, sleep. Thank you. Yeah. All right, everyone, I'm going to give you instructions. Are you all able to hear me? No. All right, so we'll have them move out. Could the jurors who were excused, if you could move up and please just lower your voices a little bit. Thank you. Is everyone able to hear me now? Okay, who's not able to hear me? All right, you can move to one of the open seats. If you see a seat that's open, you can come forward because they're already distanced. Okay, is everyone able to hear me now? All right. So this is how things will work. When you report, Deputy Laura, Deputy Mejia, if you can show yourself to the jurors, please. I'm sure they've already seen you. These two officers will give you instructions of where specifically to go. They're going to take you to the location so you will know where it is. So this room is only used for selection of juries. So we're going to be in the 187 District Court on Monday. The trial will begin at 10 a.m. If you can be there a little bit earlier before 10 a.m. so that we can make sure that you're set up and make sure that you're all here. The way jury trial works is we cannot start a jury trial unless you are all here. So if we're waiting for someone, we must wait for that person. The other thing, the 187 District Court has these fancy, snancy thermometers. I have no control over that. So sometimes it will be super cold in the courtroom, then 30 minutes later, it will be hot. So make sure that you bring a jacket or something of that nature because sometimes it gets cold, sometimes it gets hot. You are allowed to drink water, drink coffee, but make sure you have a lid on it. Our courtroom was one of the courtrooms that was flooded, so they recently put down more carpet. So I'm trying to keep that carpet as nice as possible. Before, when the carpet was dirty, I could blame it on somebody else. Now it's all me if the carpet gets stained. So just be careful with that. The other thing I want to tell you is you will be able to get your valet parking done. So you can do that each day. You have not heard any evidence in this case. Sometimes cases appear on television, sometimes they appear in newspapers, sometimes you don't hear anything about them at all. The evidence you will receive to make a decision in this case will come from the courtroom, from the witness stand. Do not discuss this case. If you happen to see something about this case come on television, just flip it to the other channel. Back in the day when I was growing up, there were only 3 channels and sometimes NBC didn't work. So now you have all these different channels. So just make sure you turn it off there. If you are on social media, people tell me now only older people use Facebook. So there's all TikTok, Instagram, all these other types of social media. If you see anything about this case, turn it off. Don't pay attention to it. All the evidence that you will receive in this case to make a decision comes from where? Yes, in the courtroom. So just make sure you do that because everyone wants a fair trial. Okay. Now, is there any question about anything? Yes.
Yes, ma'am. I am self-employed and because of the COVID, and I don't know if this is the appropriate time, but because of the COVID, I've had to down staff and I am the owner of my company. I don't have a lot of time. Is there any way I can be excused?
No. Thank you. Thank you for asking. That's why at the end of voir dire, the state and sometimes defense will ask, is there anything else that we should have asked anyone that you feel we need to know? What I can tell you is because I'm aware of traffic downtown, it may not be as bad as it was before, but I always make sure that we stop by 4:30 unless we're in the middle of testimony. That way you can get out of the garage and get home because the garage that you'll probably be parking in, I didn't design it, but somebody designed it where there is only one way in and one way out. So if I am able to stop testimony by 4:30, you won't have any problem getting in, getting out. If you arrive at the parking garage by 8:30, there will probably be a space available for you. Deputy Laura, I don't think we have designated spaces where it says, so there are no designated spaces. It's first come, first serve. In order to make sure that you have a spot, you don't have to drive around downtown. You probably need to get here earlier. Any other questions about anything? All right. And when, yes.
Hi, where do we meet on Monday morning?
All right, Deputy Laura will give you instructions. She's actually going to take you to where you need to meet. I'm not great at giving directions, but it's the 4th floor of this building and it's toward the light. So, but she will show you which direction, where you need to go. All right, anything else from either juror? Anything else from the state? Defense?
No, Your Honor.
All right, then I will see you all on Monday at 10 a.m. We're going to start exactly at 10 a.m. if everyone's here. All right, thank you again for your service. Everyone, please rise. And everyone, we're going to stop live stream and we're going to go to